Well, hello again. We are back for the final segment, applause, of my presentation on the legal context of environmental law, sustainability, the subject of this course. And what we're going to be doing now is looking at objecting to rules, the processes, somewhat less formal and certainly highly politicized processes that people use to object to rules. And just want to refresh your memories very quickly. Agencies, the EPA in this instance, make three kinds of rules. The first are interpretive rules. The interpretive rules enable the agency to figure out what it is Congress wants them to do. Substantive rules, how they're going to do it. In other words, what regulations they're going to have, what they're going to prohibit, how they're going to do the research, who's going to do the research, and so on and so forth. And then finally, procedural rules, reporting requirements, and penalties and adjudication, you name it. For example, if a guy gets, I was giving you that example of the tannery before, and the chemicals that seem to lead to cancer, what's known as a cancer cluster, an abnormal number of cases of a similar cancer. That guy is entitled to certain due processes, right? He's entitled to certain procedures before he can be fined or have his business shut down. So let's proceed, and I'll tell you a little bit more about that story when we get to it. So anybody, governments, persons, organizations, individuals, we already said that, often object to rules made by agencies because they believe them to be contrary to their interests. And so if an agency's rule is harming your business or otherwise your interests, what you want to do is show that the agency made a mistake, because you can't say no to a valid rule or to a valid regulation. So what you do instead is you challenge the validity of the rule itself. I hope that's clear. There are, at the national level under the EPA, and this is very similar at the state level, of course, as well, but at the national level, there are basically three places you can take your objections to a rule. One of them is to Congress, the people who made the law that generated the rule. Secondly, you can go to the courts. And thirdly, you can go to the political directors. As it says there, the political directors of the executive branch. Of course, the political director-in-chief happens to be the President of the United States, right? And then all of his advisors, including all the cabinet secretaries. And yes, in the case of the EPA, it's not a cabinet secretary. The head of the EPA is an administrator, the administrator. That's his title. Okay, so the first place you might turn to perhaps overturn a rule to which you object because you believe it's harming your interests is Congress. And in Congress, and again this is true at the state level and at the local level in the legislatures, there's something known as legislative oversight. Now the legislatures are the ones who authorize the money that the executive branch uses to pay for the activities that the agencies undertake on the basis of their interpretation and their substantive rules and their procedural rules. So because Congress is authorizing the money, the president can't just start spending money. He needs congressional authorization to do that. Because Congress authorizes the money, Congress also has the right and the ability to oversee how that money is actually being spent. And that's called legislative oversight. We're all familiar with this. When Congress conducts hearings, right? All these hearings we hear now about the FBI and all these investigations surrounding Hillary Clinton's emails and all that. They conduct hearings. They conduct investigations. The members of Congress will ask questions of various administrators and officials and so on and so forth. How did you reach this conclusion, and so on and so forth. Now, when Congress finally gets through its legislative oversight, say the Committee on the Environment, for example. And Congress is through that process, has completed its investigation, and that committee then reports out to the chamber, to the House of Representatives, to the Senate. Yes, this is what we found. They may find that the agency did indeed improperly interpret the will of Congress. At that point, they might be able to persuade the agency to change its rule. But as you might imagine, agencies are going to be pretty reluctant to change their rules because, well, they're the ones that reach the conclusion. So Congress might have some negotiating power, as in, hey, you know what, we control your budget next year. If you don't fix this for us, maybe we're not going to fix your budget, or authorize money for other priorities that you have. However, if Congress can't get the agency to change the rule because the rule is valid, another thing that Congress can do is to change the statute so that the intent of Congress is changed. And that's certainly something that can come from the legislative oversight process, but it's rare. And of course, these days, it's extremely rare to get Democrats and Republicans in both chambers to agree on anything. So it would actually be fairly difficult for Congress to undertake that kind of revision of an unliked rule. And of course, that's coming probably from businesses and members' districts and corporations and so on and so forth. Another factor to consider is even if Congress were to pass a law changing its intent, the president might not support that law and might not support that change of intent. And if Congress can't override the president's veto, well, presumably you know the rest of that story. Using the courts. This is a fairly, increasingly, not just fairly, but increasingly common avenue for people who object to administrative rules. Scott Pruitt, for example, now the administrator of the Environmental Protection Agency, as Attorney General for the state of Oklahoma, Scott Pruitt filed dozens of lawsuits against, guess who? The Environmental Protection Agency. Why? Challenging rules that the EPA had made. Sometimes he won, sometimes he lost. You're also probably familiar with this process with Obamacare. Lots of lawsuits filed under Obamacare. Right? Courts are, first of all, powerless to go out and get a case. So the first thing that has to be said here is that cases have to come to the courts. Courts can't say, we think that rule looks questionable, we're going to review that. The court can't do that. Somebody actually has to challenge the rule in court. And by the way, this could be challenges to a rule because the rule is too cumbersome and too stringent and too costly, or it could be the rule's not strong enough. Courts also are limited in that in order to invalidate a rule, they have to find that the agency did not comply with what's known as the Administrative Procedures Act, which is a large piece of legislation that was passed right after World War II, governing administrative behavior. The people who backed it were very upset at the very, very large government that had grown under Presidents Roosevelt and Truman. And so they wanted to make sure that administrators were not behaving arbitrarily. So anyway, the Administrative Procedures Act is very well known to public administration students, and in other contexts you may certainly come to know. But it has all sorts of rules about how agencies are supposed to make rules. There are all sorts of rules in the Administrative Procedures Act about what procedures agencies are to take when they are interpreting acts of Congress. And if they find, if the court finds that yes, the agency did comply with all the procedural requirements in interpreting this act of Congress, the court might nevertheless find that the agency did not make a reasonable attempt to interpret the statute. That, maybe there was some partisan bias, some set of assumptions. But for the most part, it's difficult for the courts to overturn rules unless there's been a clear APA violation. We will come back, just allude to that, we will come back to Massachusetts versus EPA in a few moments. Okay, finally, if you object to a rule, you can go to the person who is in charge of the rule makers. That is the President of the United States, who presides over all of the administrative agencies in the executive branch. You can see on the slide there, it also says rules and regulations and directives coming from the President or from his designates. And those designates would be cabinet secretaries, undersecretaries, assistant secretaries, and the like. And what all of those individuals can do, from the president on down to assistant and undersecretaries, what they can do is they can order a particular division or department within an agency to redo its interpretive, substantive, or procedural rulemaking, decision-making. Now, why would agencies do this? And as the slide indicates, there are lots and lots and lots of sources of pressure on administrative agencies and their political directors, from lobbyists, legislators, their staffs, state and local officials, and of course, direct contact by business. So one of the things that you should be thinking, this is kind of an ethical question as well as a legal question, you should be thinking, is it appropriate once Congress has passed a law and an agency has interpreted it, is it appropriate for the executive branch through its political directors to change the meaning of the law by directing the agency to perhaps change its rules? So this is where it gets interesting. As it says at the top of the slide there, executive orders coming from the president are superior to any rulemaking decision, any cabinet level decision by an agency. During the George H.W. Bush administration, he of the overridden veto on the Clean Water Act, during the George Bush administration, his vice president, Dan Quayle, presided over a committee in the White House, in the executive office of the president, which would review all legislation and all rules creating new environmental regulations. And if they were too costly, they would apply cost-benefit analyses. If they were too costly, that committee would recommend to the president that he order the agency to rewrite the rule and to make it less costly, to find a way to make it less costly. These kinds of committees, these kinds of restrictions, of course, are highly favored by the business and financial communities because, after all, they're all about costs, right? The banking industry right now is working very, very hard to roll back some of the regulations and rules that came out of the financial crisis of the late 2008, 2009, the early Obama administration. President Obama also certainly did things like that, but of course in another direction. When rules, as I say, when rules were not strong enough. I mentioned environmental justice before, and the president's, the administration of Obama actually did make environmental justice a higher priority. So again, you can go to the executive branch, or the executive branch can actually take this kind of pre-clearance oversight experience, almost like the legislature, to make sure that the agencies are making rules consistent with what, well, the administration was directed to do. Okay, Massachusetts versus EPA. It's a really interesting case, but I'll give you the sort of thumbnail version. The George W. Bush administration in the early 2000s issued an executive order saying that under the Clean Air Act, EPA was only to regulate particulate pollutants. That is, pollutants that have lead and mercury and other types of minerals, etc., but not carbon dioxide, which is simply a gas. Well, carbon dioxide, as you know, is a greenhouse gas. And, advocates of climate change science say that excessive amounts of carbon dioxide put into the atmosphere by industrialization is what is causing climate change and so on and so forth. But the Bush administration, because industry, coal industry, steel industry, carbon dioxide, the automobile industry, emitting industries, they didn't want the EPA setting rules on that, and so the Bush administration ordered the EPA not to do that. It said our interpretation of the Clean Air Act is that it does not include carbon dioxide. Now, interestingly enough, as I said before, the court can't go out and get a case, can't make a case. Likewise, you can't bring a case to the court unless you are directly affected. And that's what we call the problem of standing. And in this case, Massachusetts was challenging the EPA, as directed by the Bush administration, challenging it, claiming that it had an interest because if carbon dioxide levels were indeed leading to climate change, sea levels would rise and Boston would go underwater. Kind of funny to talk about that right before the Super Bowl. But anyway. The court ruled that Congress did intend for the EPA to formulate rules regulating greenhouse gases. Now remember, Congress could easily, well, let me get to that in a second. So the court basically said, President Bush, your agency, the EPA, needs to interpret that statute as actually meaning to regulate carbon dioxide. And Bush, because he has to comply with the law, right? He's sworn to uphold the law. President Bush rescinded his executive order, and the EPA started putting out regulations regarding greenhouse gases. Executive orders and regulations, which are now going to be rescinded, as I'll say in a moment, by the current president. One other thing to note about Massachusetts versus the EPA is that Massachusetts versus the EPA is not a constitutional case. It doesn't ask any questions about whether what the EPA did or what the president did was constitutional. Everything the EPA did, everything Congress did, everything the president did was constitutional. What happened was the president misinterpreted a statute, and what the court did was to reverse that misinterpretation. So again, the court was not looking at the Constitution in this case, it was simply looking at a statute, which means if it were able to act, Congress could reverse that court decision by passing a new law removing greenhouse gases from the Clean Air Act. And as parallel there, you probably know, of course we all know, that medical marijuana and now recreational marijuana has been legalized in several states. But marijuana remains on the Controlled Substances Act list of controlled substances. And until, well, basically beginning in the Obama administration, the administration said, you know what, we're not going to enforce that. So states, if you want to have medical marijuana distribution laws, if you want to have recreational distribution laws, you go ahead and do that, even though it's on the controlled substances list. Well, just recently, Attorney General Sessions announced we're going to revisit that decision too. So here's all these states that have marijuana laws, technically in violation of the Controlled Substances Act. My point in telling you that story, Congress could do something about that. Congress could remove marijuana from the list of controlled substances, but it's very unlikely to do that because there are large numbers of people in their constituencies who would be very, very upset by that. I wanted to mention a little bit more about NEPA and the NEPA process. NEPA basically asks all federal agencies to stop and think about whether a project that they are funding or directing will harm the environment, and if so, in what ways and how much. Now, as I mentioned earlier in segment number 1, NEPA requires the agencies to undertake an environmental evaluation. They will, if it's a large project with clear environmental consequences, they will be required to do what's known as an environmental impact statement, which is a very, very complex, very cumbersome process. If it's not quite as clear that the project is going to have environmental impacts, the agency can then do what's known as an environmental assessment to determine whether or not there's enough environmental impact to justify a full environmental impact process. Very, very cumbersome, very, very expensive process. But when Congress crafted this legislation, the purpose was to make sure the government was not going to be doing any more damage to the environment. If you remember Lyndon Johnson's comment, we can't replace the prairies and all the wonderful things we have out there, but we certainly can preserve those that we have, and that's the idea behind the EIS. It's a very cumbersome process. If you look at the first, or actually the second bullet point on the slide, when I say agency-funded projects, that means projects that the agency is doing on its own, or projects that the agency is sharing through funding with subnational governments like state and local governments and private companies and developers. Anytime there's a project that has any federal funding whatsoever, it is subject to this NEPA process. Right, and again, there are lots of people who object to that. And those objections take place in the Congress, in the courts, and in the executive branch, just as I was describing earlier. So this is what's really interesting. Presidents, even of the same party, will often reverse the actions and interpretations of their predecessor. Right? So if a Democrat, if Hillary Clinton had succeeded Barack Obama, she would have probably reversed some of Obama's executive orders. Likewise, when George W. Bush was elected, when George H.W. Bush was elected to replace President Reagan, he actually reversed some of Reagan's executive orders. Executive orders only have the force of law for as long as a president endorses them. And they can be reversed, they can be amended, and they can be eliminated. The classic example of this is every time a Republican takes office, family planning funding in foreign aid to governments that support and NGOs that support abortion services will not receive that foreign aid, so that will be banned. Democratic presidents, of course, reverse that. So George W. Bush had signed an executive order banning the use of foreign aid or distribution of foreign aid to governments and NGOs that also happen to perform abortions. The Obama administration reversed that policy. And I leave you with this. Hooray! If you go to whitehouse.gov, you will see the following language by President Trump. Ending intrusive EPA regulations that kill jobs, hurt family farmers and ranchers, and raise the price of energy so quickly and so substantially. rolling back, well, so first of all those regulations to which people in the energy industry and other industries object to will be rolled back by Administrator Scott Pruitt and, at the direction of the President of the United States. Secondly, and more significantly, President Obama's administration formulated the Clean Power Plan. And the Clean Power Plan was essentially intended to cut back on the use not just of fossil fuels in general and to encourage alternative forms of energy, sustainable forms of energy, renewables, but in particular to cut back on the burning of coal, which is frankly the dirtiest of the bunch, right? But it's very efficient, it's very effective, right? It's been in use for a long time, goes back to, well, ancient times. But the Trump administration is eliminating that entire program by executive order because it was created by executive order. You are familiar with the Dreamer problem, right? DACA on immigration. President Obama issued an executive order protecting children who were brought here illegally from deportation. President Trump has said he's going to rescind that executive order unless Congress acts. And so with that, I bid you good evening or good day. Oops, hit the wrong button.